Good evening, everyone, and thank you for joining us for the webinar on contractual interpretation, the common law plea of an implied term. It is a delight to welcome our keynote speaker, Advocate Rajnish Kumar, a general litigator with an experience of over 8 years in handling contractual breaches and damages. He carries a diverse practice portfolio from commercial litigation and employment matters to intellectual property and family disputes. Rajnish has represented clients before various legal fora, including the Supreme Court of India, and has served on the panel of court commissioners and receivers in the District and Session Court in New Delhi. He is the co-founder of a law firm, Actus Legal, and impaneled with government organizations such as India Limited, Hindustan Steel Constructions Limited, and IFCI Limited. When Rajnish is not in court, you can find him continuing his family legacy in the craft of Madhubani paintings or writing articles for late newspapers like the Financial Express. As a housekeeping tip, please may I request the audience to keep their speaker phones on mute during the presentations and the video mode turned off. We encourage you to ask questions by placing them in the chat box. While we may not be able to take all questions, some of these questions could be addressed during the Q&A. Today's discussion focuses on the Indian position and interpretation of a common law contractual concept called implied terms. The question is, how successful will a plea on implying a term in a contract be before the Indian courts, and what are the legal principles considered by the courts while accepting such a plea? The question is considered in light of the recent Supreme Court decision in Naba Power Limited versus Punjab State Power Corporation Limited. As a way of a background, we have the Punjab State Electricity Board that was unbundled in 2010 to give rise to two companies. One of those companies was the Punjab State Power Corporation Limited, or let's just call it Powercom. However, before the reorganization process took place, the Electricity Board had invited bids to select a developer for long-term power procurement. Now, for this purpose, the Electricity Board had incorporated a new company called the Naba Power Limited that was to serve as a special purpose vehicle. And the question is, what is a special purpose vehicle? Now, an SPV, as we call it, is an entity that is created for a specific purpose, generally as a risk hedging mechanism to distance the business of the company, or in this case, of course, to distance the Electricity Board from any financial uncertainty posed by this new venture of power procurement from the private space or the private sector. Now, the idea behind floating Naba Power Limited was for the bidder to acquire 100% shares of this company and enter into a 25-year power purchase agreement, or a PPA as we call it, with the Electricity Board. Now, the bidding process took place and Messrs. L&T Power Development Limited was the successful bidder, which entered into a share purchase agreement with the Electricity Board for transferring 100% shares of Naba Power to L&T. Subsequently, the power purchase agreement was also entered between the Electricity Board and Naba Power Limited, with of course L&T acting through Naba Power Limited. Now, the dispute began from the first invoice generated by Naba for supplying power. Naba had billed the Electricity Board for the cost of washed coal that was used in the power generation process. However, with the unbundling of the Electricity Board into these two companies, the obligations of the Electricity Board were now undertaken by its successor, Powercom. Powercom disputed this amount, alleging the cost had to be borne by Naba for the washed coal as per the power purchase agreement. In essence, the Supreme Court observed the dispute was of contractual interpretation, which is how do you interpret the various terms in the power purchase agreement, particularly with respect to coal. Because if you look at the power purchase agreement, it simply referred to the term coal and not really washed or unwashed coal. Now, in terms of the evidence, before this power purchase agreement was signed, Powercom had mandated the successful bidder to arrange for washing of the coal. L&T had raised a query as a pre-bid clarification on whether the coal supplied for the project was washed or unwashed coal. Powercom's response was that L&T was to arrange for washed coal. If one considers the question, the issue was which type of coal needs to be arranged by L&T for the purpose of power supply, and not really who bears the cost associated with the arrangement. The issue was whom did the obligation to pay for washed coal lie? Was it Naba or was it Powercom? Naba referred to an energy charge formula in the PPA, and it was on the basis of this formula that Powercom was supposed to be paying Naba for the power supply. And so when Naba referred to this energy charge formula in the PPA, it interpreted any reference to coal and fuel in this formula as a reference to washed coal. And therefore, any cost for purchasing, transporting, unloading coal had to mean that cost for washed coal. Now, Powercom, on the other hand, had contended that washing was not a part of the energy formula, and consequently, it had no obligation to pay for the washing. Powercom said, look at the PPA. Where does this energy formula say or use the word washed? It doesn't. And therefore, we have no obligation to bear the cost of washing the coal. Now, this brings us to the broader theme of the webinar, which is, can this term washed be implied in the energy charge formula and therefore be made a part of the power purchase agreement? Now, let's look at the legal principles. The legal principle is that a term is implied in a contract to accord business efficacy, which means apply this term washed if it is important for the business aspect or business efficiency. The idea behind implication is to give effect to the presumed intention of the parties. Why? Because if the parties had already decided something, they had already reached a consensus per se, that would have been expressed in the contract. Hence the word presumed. However, courts are cautious before implying a term in the contract, as the object is to give meaning to the contract and not merely start adding terms for the sake of adding a term. Because the courts have the power of implication, that doesn't mean that they'll simply start adding terms to contracts. Because at the end of the day, contract law is within the private domain, and the court should be cautious while entering that private domain. As a pure common law concept, there are certain legal principles that have emerged from leading cases to determine whether a term should be implied in a contract or not. Now, these legal principles have been provided in the Privy Council decision of BP Refinery Western Port Private Limited versus Hastings Shire Council. And this was a decision of the 1970s. Now, an interesting part is that both UK as well as Australia, when they have their legal principles on implied terms, they also rely on this case of BP Refinery. So we call this case, of course, the BP Refinery case in both these jurisdictions, and that's the applicable law for interpreting or applying the legal principle of implied terms. Now, this case sets out a 5-point criteria for implying a term. Now, the first one is the term is implied to accord reasonableness and equity in the transaction, which means you imply the term because it's reasonable and there has to be some amount of equity that you're doing to both parties. Second, that the situation is such that it necessitates business efficacy because the contract will not be effective without the implication. That is, there's something incomplete here. We need to complete it. Of course, where the contract is effective without implying a term, the term will not be implied. And the most important here is the third point, which is that for a term to be implied, it must be so obvious in the given context that it goes without saying. Fourth, the term implied must provide clarity. And fifth, the implied term should not be contradictory to any other term in the contract. So these are the 5 principles on the basis of which the courts assess whether the term should be implied or not. Now, this 5-point criteria is not a checklist, which is the court is not going to sit down and say, oh, point 1, is it complete? Point 2, is it complete? Oh, okay, point 3 is not complete, and therefore we will not imply a term. No, so it's not like a checklist, but these are certain factors that the court keeps in mind, or the court is guided by these principles for the purpose of assessing whether to imply a term. Now, India is aligned with English and Australian law by adopting the 5-point criteria in BP Refinery. In fact, this criteria was the foundation of the Naba case. Now, the Naba case is important for a number of reasons. First, it is the most recent authority from India's apex court on the contractual principle of an implied term. And second, it provides a historical journey by citing relevant precedents from common law on the evolution of the concept, including various interpretations adopted by judges on when and how should terms be implied in contracts. So, for instance, the Supreme Court centered its attention on an old English case of the Moorcock, which was way back in 1889 that it was, I think, decided, to understand the legal principles behind implying the term. Now, one can say the principle of implying the term is to give effect to the intention of the parties and preventing a failure that had not been contemplated. And I think the emphasis here is more on preventing some sort of a failure. Most importantly, the case stands as authority for the principle that a term is implied in a contract only if it had been intended by all parties to provide efficacy. Essentially, it can't be one party's intention that the court is giving effect to, or it can't be a one-sided burden which the court is tilting in the favor of. Rather, it has to be a presumed intention of all of the parties. So there are 3 of you in that contract. All 3 of you should have had the same presumed intention. It can't be that the court is simply convinced by the argument of one of the parties and the court is tilting in favor of that party and therefore decides whether to imply or not imply a term. No, it has to be that the court is convinced that this implication or this intention is presumed for all of the parties. Now, we can draw an analogy between implied terms and the law of frustration. In fact, when the principle of frustration were initially embedded in common law, it was through an implied term. The case on point is Taylor versus Godwil, where Justice Blackburn, who I believe is a genius, was a genius, stated that if parties had known from the beginning that a contract could be fulfilled if the subject matter of the contract, in this case it was the Surrey Gardens and Music Hall, continued to exist, then the parties must have also contemplated what was to be done when the structures had perished in an accidental fire. Now, why do you think Justice Blackburn made this statement? Because what was to be the consequence in case the structures perished was not a part of the contract. It was not an express term in the contract. And what Justice Blackburn says next here is important. He says the contract in such cases cannot be construed as an absolute or positive obligation that needs to be performed under all circumstances, unless, of course, there is a warranty by the promisor to perform regardless of the supervening circumstance or regardless of the fire. Which in essence, what Justice Blackburn is trying to say is that where you've got these structures that have perished because of a fire, and that's an accidental fire without the fault of the promisor, we can't really impose on the promisor to make those structures available. It's not a positive obligation. It can't be a positive obligation, particularly where you've got a supervening circumstance beyond the control of the promisor. So, in those circumstances, what can be done? And in those circumstances, Justice Blackburn allowed a term to be implied, or there was an implied condition. And what was the implied condition? That the parties allowed each other to be discharged from the contract. And therefore, the promisor did not have that absolute obligation to make the structures available for the event that they were booked for. So the emphasis is on the term implied condition. Now, the parties in this case entered into an agreement to use a music hall and the surrounding Surrey Gardens without a force majeure clause. And the issue was, should the promisor be excused from their promise when these structures had perished in an accidental fire prior to performance? And Justice Blackburn saw a failure here, which the parties were seeking to prevent. And what was the failure as far as implied terms was concerned? The failure was the failure to recognize supervening circumstances such as a fire making performance impossible. The law back in the day was absolute performance because we had Paradine versus Jane that was ruling the law at that point in time. And according to Paradine versus Jane, well, if you've undertaken a promise, as a promiser, you perform it. Regardless of thunder, rain, sunshine, doesn't matter. It's a private obligation you've undertaken. It's not a public duty, and therefore you perform. So there had to be a way around Paradine versus Jane, and therefore Taylor versus Godwil. In some ways, you could say, and there is a fair amount of academic debate on this, whereby Justice Blackburn went around Paradine versus Jane in this particular case of Taylor versus Godwil to allow an implied term. And he borrowed this concept of an implied term not from common law, but from civil law. In fact, it was Roman law that he had cited as a part of the judgment. So the law back in the day was absolute performance, which would have meant the promisor had to make the structures available on the dates booked for their use. Now, this was not possible since there were no structures, and the promisor would otherwise be liable for breach, and it wasn't his fault. It was an accidental fire. Now, did that seem fair? Did that seem equitable? I think Justice Blackburn saw some sort of an inequity there, although he doesn't say it so much. By implying the term of discharging the parties from performance and not declaring a breach, Justice Blackburn had sown the foundation on the law of frustration. Although if you look at Taylor versus Godwil, Justice Blackburn does not use the term frustration. But I think by implying this condition, he was heading towards or sowing the seeds of frustration as we know it today. That's why under contract law, Taylor versus Godwil is one of the cases that we read as a part of frustration, although we don't see that explicit term frustration being used in the judgment. Now, coming back to Naba, Justice Cole and Nariman in the Supreme Court relied entirely on common law to interpret the agreement, and this brings me to a notable point. Now, the Indian Contract Act 1872 is a significant piece of legislation on general contracts that sets India apart from Australia and UK, where a similar legislation has not been codified. Rather, reliance is placed on common law. However, even in the Indian context, disputes on interpretation of contracts have benefited and relied heavily on common law. Naba is one of the many examples. Now, while Section 9 of the Indian Contract Act states promises can either be express or implied, whether a contract contains an implied term is a matter of contractual interpretation, which the Indian Contract Act provides limited guidance, and common law precedents have aided in this sphere. In my opinion, Naba can be distinguished, coming to another point of distinguishing Naba from Smith versus Hughes, which students undertaking contract law 1 might be familiar with. Now, in that case of Smith versus Hughes, there was a mistaken belief in the mind of the promisee on the specific nature of the products being purchased, which is, were they new oats or were they old oats in a sample by sale? Now, the promisee, after inspecting the sample, mistakenly believed that the sample was for old oats, while the sample was in fact for new oats. So, this was a unilateral mistake in the mind of the promisee of what the promisee had seen, and therefore contractual rescission was not permitted. In the Naba case, the issue is not whether L&T or Nabha Power were under a mistake on the payment of the coal, for they did make clarifications on the type of coal that was to be arranged. There was due diligence undertaken to avoid a mistaken subjective intent. Although one can discern similarity between the cases of mistake that do require contractual interpretation and cases of implying a term for business efficacy, but the common law rules on both seem to be different. Now, it is true, both cases of assessing acceptance in a sale by sample and, on the other hand, implied terms require contractual interpretation, but further investigation on the similarities and differences between the two could be a potential area of academic study, at least in the Indian context. Now, given Naba was not a case of mistake, Justice Kaul and Naraman referred to the popular test of an officious bystander, which, if we look at BP refinery, was point number 3. And as I had mentioned, point number 3 was an important one. And the officious bystander test is coming from the case of Sherlaw versus Southern Foundries to discuss the significance of obviousness. That is, the term should be so obvious that it should be made a part of the contract. Now, the test of the officious bystander is if a bystander listening to the negotiations between the parties were to suggest an express term, right? So let us say Rajnish and I had were negotiating a term, and then let's say we've got Nishant or Vindhya coming in, and they were hearing our negotiations. But we hadn't really thought about this concept of, okay, should there be greater clarity to the type of coal that we are using in the PPA? And let's say Vindhya or Nishant suggest, okay, why don't you make the type of coal in this case explicit? Call it washed coal. And both of us, that's both me and Rajneesh, should have said, yes, of course, yes, as a matter of immediate agreement to incorporate washed coal as a part of the agreement. So the hypothetical bystander test seems to suggest that parties may have inadvertently forgotten to incorporate a term, but had they brought their minds to it or had someone prompted them, they would have obviously agreed to incorporate the term during contract formation. Now, implying a term cannot be used as a way of incorporating a term that had been rejected during contractual negotiations. Now, for the term to be implied, it must have been in the mind of both parties. And that's the hard part. How do we know what is in the mind of both parties? And somewhere a reasonable assessment is required. Now, this is not to say the officious bystander test is the same as a reasonable assessment test or the reasonable person test. Now, while there is scope of greater clarity on this aspect and is a good space of academic discussion, the case of Sherlaw itself points to the difference. It isn't about whether a third party observes the conduct of a person to assess, okay, is this person accepting the terms of the contract, and whether the other party who is hearing that acceptance or is reading that acceptance, for example, is led to believe that there is in fact acceptance to the terms of the contract, right? So that's what we see in the reasonable person test. Which seems, of course, different to the officious bystander test, where the officious bystander is providing a specific term and suggesting perhaps this term should be incorporated in the contract or should be discussed about it. So there are similarities and differences between the reasonable person test and the officious bystander test, but they're meant to be different and treated differently. Another interesting point of discussion is whether a term should be implied in a contract out of necessity or reasonableness. Now, that is, should a term be implied because it is reasonable or because it is necessary? Now, the necessity approach had been adopted by Justice Denning at the Court of Appeal in Liverpool City Council versus Irvine, who had referred to commonly accepted business relations such as hire, sale, or rent, and noted the courts in none of these cases asked the question on intention of parties or whether it was necessary to give business efficacy. The reason for this was the courts were deciding cases for a certain well known category of business relations, right? And I think somewhere the laws now have been refined and taken into account the certain category of relations. So we've got specific legislations whereby we're looking at transfer of property or we're looking at sale of property. So sale purchase agreement with respect to immovable property have their own set of rules and regulations. So in those cases, you're going more by the legislation than by the intention of the parties because you have to read the intention and you have to read the contract in context of that specific legislation, right? Um, so that's what I think Justice Denning is trying to allude over here, that where you've got these well-known category of business relations, um, the courts are cautious to ensure that implication would be fair and just to the parties falling within the category itself, uh, regardless of the specific circumstances of the case. The circumstances are considered, but within that broader parameter or the broader sphere of the category itself being regulated. Now, where there is no predefined relation, an implication necessarily arose out of the intention of the parties underpinning the existence of the term. So, where you don't have these well-defined relations, of course, there needs to be a necessity of implying a term because the parties themselves wanted the term to exist. So the court, of course, cannot impose its own understanding of reasonableness because that would mean entering the private domain. Now, other judges in common law jurisdictions have attempted to resolve this issue by holding the underlying principle of implying term to give effect to the presumed intention of the parties, whether that be through the test of necessity or reasonableness. According to these judges, the outcome would be the same because you're trying to give effect to the presumed intention. Now, the Supreme Court in this case of Naba was rather cautious in ensuring that it did not substitute its own view on presumed intention between the parties, particularly if the terms were explicit in their expression. Now, explicit words were final between the parties. The main criteria for implying a term in a contract was if the implication was just and reasonable. Now, when it seemed the Supreme Court was leaning towards reasonableness in deciding the case, it quickly considered the necessity approach and stated that, look, a term was implied if it was necessary for giving business efficacy to the contract. So it's considered both. The court noted that the clarification received by L&T during the pre-bid stage to arrange for washed coal did not imply that L&T was required to bear the cost of washing the coal. The energy formula was the basis of calculating the price of the coal, right? And who was going to be paying for all of this? It was Powercom. Now, applying the principle of business efficacy, the Supreme Court ruled that the monthly energy charge formula had to be interpreted in a manner normally understood. And what was that? That washed coal was a necessity for this project and was a quality requirement for the formula. And therefore, this formula included the cost of washed coal. Why? Because that formula was brought into existence or that formula was there for the purpose of obtaining the quality of coal, which meant that whenever there was a reference to coal, it had to mean washed coal for the purpose of maintaining the quality. So this meant that the term washed was implied in reference to the coal considered by the energy charges formula. So the cost of washing was to be borne by Powercom because they were going to be paying for the power. So I now hand it to Rajnish for taking the discussion forward and sharing his experience as a founding partner.
Good evening, everyone. I'm thankful to Jindal Global Law School, Divyangana, the other speakers for becoming part of this series, webinar series. Most importantly, Divyangana has explained the topic so nicely that I think I have very less to speak, and I felt really good that I'm actually learning a lot because she touched all the issues of this interpretation of a commercial contract. But just a point, I see some very good, the participants are there. They don't need the definition of the contract, the Section 9 of the Indian Contract Act. But at least for the convenience, I will just introduce it. When we talk about contract, the most important thing which is happens, that is the meeting of minds. That is consensus additive. So when there is a meeting of minds, then the parties intend to the consequences of the contract. It is more applicable in the one-to-one contract, but when there is a commercial contract, then there are involvement of lot many people, there are involvement of lot many processes. So there it may not be possible, but at the end of the day, it is the purpose of the contract. That is why the contract is being formed, whether both the parties are intending to the same fact on which they are agreeing to. When the case of Naba Power comes into the picture, there the dispute was of price of a coal, that is washed coal, unwashed coal, where the three words were very important, that is purchasing, transportation, and unloading of the coal. So just taking an example of any other product, be it coal or any other thing. So when it is purchased, then the transportation, and third, the unloading of the thing. Now there was another few words which played a crucial role in interpreting the concept, that is to and at the project. So this word to and at. So when the judge, it was interpreted by Honorable Justice Call in the judgment, it was like they said in the later part of the judgment, which I will refer a little later, that they are not giving the implied term, they're not interpreting it, they are just giving meaning to the word so that the actual real intention of the parties comes to the picture. Now, how it was interpreted and whether the implied term was actually whether there was an implied term which Justice Call interpreted, or there was an express term. So Justice Call in their own judgment said, I have not implied, I have not given any meaning, whereas I have interpreted the word which was already in existence. In the same way, as Divyangana has already referred the 5 principles, which I was also going to refer, and again the Moorcock test laid down by Lord Justice Bowen, where they talk about the business efficacy. Now the principle has evolved a lot from 1889 till today. The judgment of Naba Power is a classic example when we have to refer what is the meaning of implied term, what is the meaning of express terms. We can refer this judgment and see how an interpretation is being given to a commercial contract. Now, when we refer Section 9 of the Indian Contract Act, we may note that the section does not talk about the word contract. It merely talks about the promises, express and implied, meaning thereby there could be, when I was reading the section, I said the word contract is not there in this section. The word promises is there. So when we talk about promise, of course, all the promises or the set of promises are the agreement. But again, when we get into it, all the agreements are contract. But if it is enforceable, then only. If it is not enforceable, of course, it will not be a contract. Now, when we go deeper into the interpretation of the contract, when we go to the court and interpret the term, so what is our perspective being a litigator? How do we interpret, and what do we try to give the logic or the reason for interpreting a term? It is basically it from, of course, the laws. If the principles are there, we cannot deny that. We cannot set it aside, but we can only take the help of that principle in interpreting or in making our argument or in advancing our argument to the honorable court. Whenever there is a general term, when I was having one of the cases, then there was a case where there was some general word written. Of course, a general word incorporate everything, but can the court interpret general word in general sense, or the court will say the general word has no particular meaning, therefore the court will not get into that. In fact, in that judgment, the court says if there are general words, it means parties are not intending to something very specifically. So court cannot travel to the point what is the intention. If had there been intention of the party should have incorporated the exact word for at the time of forming the contract. The same thing has happened in this Naba power, where the Justice Paul has said, when the word is to there, like when you talk about a coal, it means you talk about a washed coal. When we talk about the food, we do not talk about like we'll go and get the potato. We want, if we are ordering something from the any like Zomato, anything, we don't say that give the potato. You give the vegetables which is cooked. So the intention of the party, when I'm running a factory and I'm asking you to provide a coal, it means I'm asking you to provide a washed coal. I'm asking you to provide a coal which can be utilized immediately for the purpose of the contract. If that is not being applied, it means the work will not happen. And if that has happened, then it is the party who is using it has the liability to pay back to the person who has, person means the company, to repay the other party who have actually utilized it. So the same thing happened. That is the price of the coal. Coal means, coal does not mean coal. Coal means a coal which can be utilized for the purpose of the contract. And then therefore the Honorable Supreme Court has interpreted the term like from where to which and at what point. We cannot simply say, suppose for an example, we order something and we say that you have to provide at my doorstep. Does not mean that you provide at the beginning, at the entry of my tower or somewhere. Where intended, what is the intention? That you will provide the product at the place where it can be utilized immediately. Means I don't need to intervene for further transportation. If I have to, I'm making things in a very plain language, because the court, the Divyangana has already used all the heavy words and the legal words. So I'm just trying to make it simple. Believing that all of you have already understood, but at the same time, yes. So contract, interpretation, intention, and then the 5 points which she was discussing, that plays a very active role. At the same time, there was a discussion in one of the judgments, reasonableness and necessity. And third, that is the business efficacy. There are other principles which also plays a very crucial role. However, I feel these 3 words plays a very, very pivotal role in interpreting the contract. When we talk about reasonableness, it means it is the reasonableness of me. I mean, the court who is interpreting it. I may feel something different. Divyangana may feel something different. We find this is a reasonable status. Someone may be having a different view. However, when the issue of necessity comes, then most of us would agree to the fact necessity means what? Necessity of the purpose for which the contract is being formed. And then business efficacy. So when I was talking regarding the point transportation and unloading, there the business efficacy comes. Suppose if I am unloading a product somewhere and from there the factory is suppose 100 kilometers away, it means the business is going to be affected. I am going to be affected, but that is not the purpose of the contract. Meaning thereby, if I have incurred certain liabilities for producing or for transporting something to you to ensure that you can run the business efficiently, it means you need to pay me back. And there the Honorable Supreme Court said, yes, there is no need to apply the implied terms. Here the word is per se there. They are just giving the word a definition. That is, there the Honorable Supreme Court said distributive theory, like distributively they are interpreting. Means when there are 2 subjects, 2 objects, they are giving meaning to all the things, not to one word. Going further, I believe I am taking care of the time. Going further, when the term was incorporated, the judgment was given. At the end of the judgment, the Honorable Supreme Court written a very word of caution, which I would like to share with all of you. And I would like to, with permission of the with consent of Divyangana, I would like to read and share the screen if she permits me to do so.
Yes, of course. Yes, Rajnish, definitely. Please go ahead.
Thank you.
Yes, we're able to see the judgment.
I hope everyone is able to see. This paragraph 72 is very important. Why it is important? Court said when there is a commercial contract, then they don't need to apply implied terms. The terms are already there. Now I'll read, and then they talk about necessity of the contract. We may, however, in the end, extend a word of caution. It should certainly not be an endeavor of commercial courts to look to implied terms of contract. In the current day and age, making of contracts is a matter of high technical expertise with legal brains from all sides involved in the process of drafting of contract. It is even preceded by opportunities of seeking clarifications and doubts so that the parties know what they are getting into. Thus, normally a contract should be read as it reads, as per its express terms. The implied terms is a concept which is necessitated only when the Penta test referred to aforesaid comes into play. There has to be a strict necessity for it. In the present case, we have really only read the contract in the manner it reads. We have not really read into it any implied term, but from the collection of clauses, come to a conclusion as to what the contract says. The formula for energy charges to our mind. So energy charges means when the coal was being purchased, transported and unloaded, to our mind was quite clear. Means if I'm talking about a coal, meaning thereby I'm talking about a washed coal. If I'm talking about unloading, it means I'm talking about the unloading at the factory, not far behind from the factory or at any other place. To our mind was quite clear. We have only expounded it in accordance to its natural grammatical contour, keeping in mind the nature of the contract. I'll just stop it sharing. Now, what the court is trying to express that, as I understand, the necessity is very important. When there is a commercial contract, as we know, being a lawyer, we give a lot of time for drafting a contract. We actually think over every word of the contract, full stop or comma, whatever we can do so. But at the same time, if thereafter some implied term, suppose the theory of reasonableness, it can be a different thing. But the necessity of the contract is always there. And if the term is interpreted correctly, then the purpose of the contract will also be achieved. Because it is not possible, humanly not possible, that when I'm writing that I need a coal, I should read a washed coal. Whereas in the same judgment, there was an opportunity for the parties to seek clarifications. The clarifications were sought by the party who were providing, transporting the coal. At the same time, even after providing the clarifications, it has to be understood that the word is there. Suppose I'm saying that you please provide me something at my place. It means I'm ready to bear the charges for the same. I cannot say that I will not bear the charges or you can provide somewhere else. No. The intention or the necessity of the contract, any contract, is that the intention of the contract, like the policy of the contract, like why the contract is being formed. And if that, without implying, without interpreting that the contract is going to be defeated, it means the interpretation is not going to achieve the purpose of the contract. So this is my understanding in a very general word, that necessity of the contract has to be taken care into, apart from as the other principles laid down, as it goes without saying. When we read a contract, we also read a contract. So then we see, okay, this is on the face of it, it looks like this. It means it has to be this. So now we have to take help of the word to get into that. When we say after looking at, oh, prima facie it looks like this. So prima facie does not mean that word has to be there, but the policy, the purpose of the contract look like this. Then the word is always there. So the Honorable Supreme Court has done the same thing in this while interpreting the word, and when the word is already there without following the implied terms. This is in brief, I believe, because she has already narrated a lot and they were very excellent. I was just thinking that she is, she is reducing my burden of explaining the topic to all the participants. So this is my
clarity has come from you. The real building. I've just given the building blocks. And now the foundation of this entire building has been made by you.
Yes, thank you. So this is my understanding. As far as Divyangana has read at the end of the my profile, that if I'm not doing law, like if I'm not in the court, I'm doing something else. So that is being, I feel, being partner of my firm. In fact, the Actus Legal. We feel that we can do, as a lawyer, we have a lot of potentials and we are capable of doing many things. But at the same time, our primary job when we go to the court is to argue on behalf of our client and follow all the legal rules and get a relief for our clients. But at the same time, when we think that, okay, we can do something else, we can help somebody else without, without investing anything. Like in today's time, you have a smartphone. We all follow, most of us, most of us are at the social, pages like Twitter, Facebook, and there we can do a lot for the public, like the one who needs. So in the same way, when we feel Madhubani paintings, like this is actually a very traditional art of North Bihar, Mithilanchal area. So we just thought, and it was being done by my family members for some good many years. We just thought to do something. And today's time, we are able to help more than 100 women. At least we are able to give 5,000, 10,000, 7,000, depending upon the work, depending upon the demand being raised by the customers and all. And we feel very happy. At least being a lawyer, I am also professionally doing good for my clients. I'm also learning a lot, because this is the profession where you learn a lot on every day. Every day, it is like on hourly basis, where I was hearing Divyangana, I was hearing Vindhya in the morning. She presented on the Biodiversity Act and the Patent Act excellently. The same, we have another very interesting lecture tomorrow on insider trading. So we are expecting a good lecture, and again a good presentation from Divyangana on the same. And this is how we presented, and this is how what I feel for the interpretation of commercial contract.
Thank you so much for that, Rajnish. And even I'm at the learning stage. I'm also learning from my colleagues in practice, and also from my students and from my other colleagues at Jindal. So even I'm at the learning stage. Even I'm trying to develop my presentation skills. But thank you so much for that fabulous and informative presentation. Yes, please.
At the trial stage, in a dispute regarding an implied term, would the court require expert evidence to be produced to prove necessity of a particular action? This is another question. In a contract regarding construction, industry, etc., or would correspondence and the contract be sufficient in proving the same? Question is not very clear, but yes, I would answer it. When we interpret, when there is a written document like written agreement, then of course there is no role for other like oral terms to come into the picture. But at the same time, suppose something is written there in the contract, and if you feel that by producing an evidence, like by bringing an expert witness to the court will not require you to do so. It is for your case, it is for you to bring the evidence to the court and prove your case. Proving your case meaning thereby there are certain, like, some relevant facts. Relevant facts are there, so all relevant fact may not be admissible. Like it is, if you think that by bringing the expert evidence for proving a clause of a contract is going to favor you, the burden is on you to prove your case. If you think the court will not say that please go and bring your expert evidence, court will say you prove your case under section 101 of the Indian Evidence Act. You have a burden of proof that you prove your case. Thereafter, the burden keeps shifting. 102, 100. This talks about that if you wish to prove your case. If you don't wish to prove, the other party will prove. So, being a plaintiff, suppose in a civil case, it is for you to prove the proofs to prove your case. Now, if we talk about expert witness, of course, expert witness per se cannot be the sole basis for a judgment. But yes, it can relate, it can help you in adding the terms. Like suppose you have already some evidence, but if you bring the expert evidence and it is not being challenged means it is corroborating with your other evidence, it is going to bring favorable judgment for you only. But court will not say, it is for you to bring the evidence and prove the facts pleaded in your plaint. I believe if the would correspondence and contract be sufficient in proving the correspondence and contract be sufficient in proving the same. Correspondence and contract, I believe he wishes to say that if there is a contract and then subsequent to that there is a correspondence with respect to the terms of the contract. See, in today's time, if you are corresponding something, being a litigator, I feel you can produce everything. We can get all whatever you wish to go and write in your pleading and all. But it depends whether it is a relevant fact. Please note the fact, every fact has to be a relevant fact, and then it will come for the admissibility. Now, after the admissibility, the another concept comes, reliability. So it's a relevant fact, suppose, and then it is admissible as well. Now comes whether the court is going to rely on your evidence. So if a fact is to be relied by the court, it means it is going to be decided. The court is going to decide the issue. It may be in your favor, it may against you. But please note, whenever you bring an evidence, a fact in the court, three things is very important. First, merely being a relevant fact does not mean the court will rely on this. Merely being a fact is admissible one, the court will not rely. It has to be, if first of all relevant, then admissible, then only court will rely. And what is the value of the evidence? Suppose you bring an evidence, expert one, and the expert witness has gone very smoothly. The opposite side defendant is not able to contradict him. It means the court will definitely rely on your evidence. Now we have another question. Sir, if there is a clash between express terms and implied terms in a voluminous standard bulky contracts agreements like loan contracts, home buyers agreements, which are mainly one-sided, what will be the courts will see, look at or look through approach? When there is a one-sided contract, the court is very clear. There is some judgment from the Supreme Court. If the other party has no opportunity to protest, suppose there is a one-sided contract, like example in most of the home buyers agreement, the builder, if there is a delay or fault on the side of builder, then builder pays 5% interest or penalty. When there is a fault on the side of the home buyer, then I have to pay 18%, meaning thereby it is a one-sided contract. It means if I say that no, I don't agree to this, means the court will, the other side, the builder will say no, I'm not going to agree. The court will definitely come to rescue if suppose you are a home buyer, and court is risking basically. The Consumer Protection Act is very clear on this, that this is basically unfair trade practice. You are misusing the dominant position. So if you have to give the equal footing to all the parties. And of course, please note, when we talk about contract, it is not a free contract. It means if I have given the option, it is the contract is being imposed on me as far as the home buyer contracts are required. Of course, when there is an express terms and when there is an implied, again, referring to the 5 principles, the last principle of that 5 is that must not contradict any express terms of the contract. So if I'm trying to, if the court, I am a court and I'm trying to refer some implied terms, whereas the moment I refer to it, I'm going to contradict and express terms of the contract. It means I cannot do, I should not go, and I'm going to commit some, it will amount to illegality. So of course, expressed terms has to be given priority, but it depends upon facts of the case. However, generally speaking, if there's an expressed or implied, expressed terms will have more value than to the implied terms. I believe the voluminous standard bulky contracts. Of course, this is like same thing. The court will see whether you have an opportunity, and these loan agreements and all. This is basically one-sided. This is called a standard agreement that you are agreeing to it. But at the same time, you also understand that all the standard contract does not mean that a court will say that this is one-sided contract. The business efficacy, the necessity of the contract, everything comes into the picture, whether you are protesting to it. Suppose this is my general opinion. If I'm entering into a loan agreement with any bank, like suppose any private bank or government bank, I have an opportunity to protest it. Of course, I will admit to it, because I have no option. If I don't agree, I will not get the loan. But at least I can protest it. This is my personal view, being a litigator. Because when we go to the court, we argue that whenever I get the opportunity, I have protested to it. It is a different thing that the other party, like the bank, has not agreed, bank has not acted on my request, but at least I did my duty. So that should be the policy. This is my personal view, because we feel that this happens in the court. Next question, sir, can public policy be imputed as an implied term? Of course, public policy, if suppose when I said section 9 has no reference to word contract. It refers to the word promises, express and implied. So if you refer section 2, section 2 of the Indian Contract Act, clause E says every promise is an agreement, or every set of promises is an agreement. And then can we say that all agreements are contract? No. Agreement which is enforceable by law is a contract. So here again, if an agreement is there and it is against the public policy, of course it cannot be a contract. So when it is not a contract, because it is merely an agreement only. Why it is not a contract? But it is not enforceable by law. If you see G, 2, G and H, when it says an agreement not enforceable by law is said to be void, means void ab initio. It is since beginning it is void, so it cannot be. It is against the public policy. If you refer section 19 of the Indian Contract Act, it's not 19, section 23. Just hold on. What consideration, section 23 of the Indian Contract Act, what consideration and objects are lawful and what not? Where you see the last one, that is, the court regards it as immoral or opposed to public policy. So if it is opposed to public policy, of course, it cannot be enforced. I believe this is sufficient for this. Any other question?
Anyone? Any other questions? All right. I think there are no further questions. But thank you so much for joining us today, Rajnish, and thank you so much for Actus Legal for collaborating with us for these webinar series. And we're very appreciative of the time of our speakers, and a big thank you for, of course, giving us the practical side of the law. As academics, of course, we provide the theoretical aspect, and that's why the webinar series have provided the practical angle to us. So thank you so much for that.